SJC-13172, Verveine Corp. et al. v. Strathmore Insurance Company et al.
Thanks. Attorney Zimmerman.
Good morning, Your Honors. May it please the court. My name is Ben Zimmerman. I represent the restaurants Copa, Toro, and Little Donkey as appellants in this case. Businesses like these restaurants buy all risk insurance policies, like the ones in this case, to insure against losses that they can't otherwise buy insurance against. The policies provide coverage when an event or a condition renders a property going from safe and usable to unsafe and unusable. The event or condition, so says the case law, can be something catastrophic, like a tornado, obviously, that destroys the whole property. It can be something annoying, like odors or fumes or smoke. Or yes, it can be something deadly and imperceptible, like carbon monoxide or a ubiquitous virus. Now, I said virus.
Mr. Zimmerman, if I could interrupt you for a moment, because I do want to talk about the case law here. I agree with you 100% that we don't weigh how many courts have ruled in the insured's favor or the insurance company's favor in figuring this out, any more than the fact that there's different outcomes doesn't in and of itself create ambiguity in the policy. But, and I also understand your position that you don't have the word physical before damages like you have it before loss. But I need to ask you for an explanation of the fundamental flaw in these cases. In Massachusetts and the United States District Court, you've got the same policy at play in legal seafoods. You've got these United States Court of Appeals cases and cases involving not just restaurants, but dental practices, the Eighth Circuit, Salinger's decision in the Superior Court, and on and on and on. What's the fundamental flaw on all of these other decisions?
I think the fundamental flaw, Your Honor, is they're not following the tenets of the law of contract construction that have been followed for decades and that we're supposed to be faithful to in this case. And that requires, among other things, that we decide whether a term is defined. If it's not defined, our case law says we construe it strictly against the insurance company. And the Strathmore has left this undefined for decades and decades and decades. And they have done it for a reason. And if we look at the amicus brief that's been filed.
Counsel, just because something is undefined doesn't mean you win or that it is ambiguous. So can you address that part? How is the forced pivot of your clients towards takeout business through the governor's order a direct physical loss or damage to property?
Well, I think you have to, and I think you've asked the question correctly, but it's been posed different ways by different courts. Has a restaurant who has lost use or access of its property, of its very business property, and remember, there were closures involved here, right? Has a restaurant who's lost use or access to the property because of a dangerous physical substance?
Let me try asking the question a different way.
Yeah.
I think your best case law is the fumes, the carbon monoxide cases. And when I look at what the Superior Court judge did, was she said those cases are different because in those cases, the fumes were actually in the restaurant. Can you address why she's wrong in that analysis, in your estimation?
Yes, she's wrong for two reasons. Number one, I do not think that those cases, including Matzner, which Judge Hinkle decided, turns on whether the substance emanates from the property, right? What we have alleged in this case
she
is that—
didn't say that the substance emanated from the property. She said that those substances were in the property. That is, the carbon monoxide was there, and so therefore nobody could use the property, or whatever the fume was, or the asbestos were. So here, as far as I could tell, Corona was not in the property. And so she's saying it's different.
I think that, well, first of all, the complaint does allege that coronavirus was present in the property in several places. It was present in the proportion that it's present in the population. It was present before the orders were issued. And if you take the
I'm sorry to
carbon,
interrupt you, Mr. Zimmerman, because I do want to get to that, but can you, about whether the complaint is enough? But I
Yep.
really, could you just answer Justice Wendland's question, and then we can go back to what's in the complaint, because I have that very same issue I really want to get to.
which is what?
Well, with Justice Hinkle's decision, for instance, you've got a chimney and it's blocked and there's carbon monoxide and it's in the building, like the E. coli and like the oil fumes and like the rug. So if you could specifically answer Justice Wendland's question, and we can debate what is and isn't in the complaint in a moment.
Right. Okay. Well, I think we have to take at face value that the presence of coronavirus is alleged in the complaint. But even if it wasn't, okay, if you look, let's just say even if it wasn't, say the carbon monoxide in Matzner came from outside of the property, say it was dangerous to enter the property. Look at the Oregon Shakespeare Festival case, which is a very interesting case, as is the Murray versus State Farm case. In the Oregon Shakespeare case, you have smoke that comes and goes. It's not deadly, it's obnoxious, and there wasn't even an order that they couldn't use the property, but they couldn't do it. It would come and it would go. We have the exact same situation here, where the virus comes in with people, it goes, and we have to reduce or eliminate our use of the property to account for that. And if you look at the Murray versus State Farm case, a very interesting case, it involves a rock slide sitting above a totally unharmed, totally habitable house, right? But it's dangerous to go in it.
Mr. Zimmerman, though, even in that case, and I admit that's a good case, but even in that case, the concern is that the rocks are a threat to a particular structure. So again, it's a good case for you, no doubt, but it doesn't get at the core of Justice Wendland's question.
Which is well, I think one of the problems is that what you're talking about is a threat to health and human safety at a premises, as well as the premises itself, right? Because the virus contaminates the premises, it contaminates people, it causes illness and death. So the fact that it's a rock slide or carbon monoxide or an illness, if it's coming through in waves and it's hurting and killing people and it's causing people not to be able to use their property, they've suffered a direct physical loss of or damage to property. And if you look, in addition to the cases that are good for me, as Your Honor says, if you look at the tenets of law, it's not defined. The dictionary definitions all support our position, which Strathmore and the Superior Court don't even mention. We have the decades of case law, including the rock slide case and the Oregon case, right? And then we have this tenet that no one seems to want to talk about, which is what would a reasonable insured expect? They're being told, don't use your property or your employees and customers are going to get sick and die, right? And so they don't, and they look to their policy, their all risk policy, and they say, geez, it says if I've suffered a direct physical loss or damage to my property, I'm covered for my lost income. I'm going to mitigate the heck out of my damages. I'm going to stay open. I'm going to fight for the insurance company's benefit. But there's no doubt in my mind as an insured that I've suffered a physical loss or damage to my property in that circumstance.
Why?
Why? Because the property is exactly the same.
But
The problem are the people coming into the property, not the property, particularly for takeout. So if there's something wrong with the property, how could they do takeout?
No, I understand. There's always this question of, was the virus present? When was it present? How long was it present? Did it do damage to the property?
And
The problem that you have,
before you leave that, because you just jump over that, but your allegations are almost exactly what the Sixth Circuit said was not enough.
well, if the problem is allegations of presence, if that is the problem, then the proper result would be to reverse it, remand it, and allow for an amended pleading, which Judge Sanders did not do. But what you're going to find when you hear from Mr. Goldman is it doesn't matter what you allege. If you allege virus was present, if you allege it damaged your property, if you allege it stuck to services, they say it's not covered. And the problem with that in this case is unlike almost any case you've read for this reason. They sold one policy that purported to exclude loss or damage caused by virus, and one policy that did not exclude loss or damage caused by virus. And they're asking you to find that both policies exclude loss or damage caused by virus. How can that possibly be? How can that possibly be?
There's a lot of different, I mean, this is property insurance, right? You didn't, I mean, there's the Wimbledon case, right? You could have bought pandemic insurance, right? There's express type of insurance to cover this kind of stuff. It's enormously expensive. Wimbledon can afford it, no one else can. But
Your Honor, if I may, Strathmore itself, okay, in the amicus brief filed by United Policyholders, tells the insurance officials in New York, we want to sell property insurance without a virus exclusion because, quote, they, our policyholders, feel that such an event, meaning a pandemic or a virus contamination at the property, is well within the real or possible fortuitous occurrence and should be covered when such an event arises. They have been asked.
Mr. Zimmerman, what are you reading from there? What is it that you're reading from? And is this in our record?
Yes.
And what is it that you're reading?
This is a filing of Strathmore to the New York insurance officials, basically saying they want to sell policies, these kind of policies, without virus exclusions.
I think you're referring to the United Policyholders amicus brief, if
Yes.
I'm not mistaken.
Yes, I am.
But nonetheless, with that amicus brief, nonetheless, to go to Justice Kafker's point, this is property insurance. If the insurer wants to put on a belt and suspenders, it doesn't mean it's not property insurance.
Right. Well, I'm glad you used the belt and suspenders analogy, because I expect that from Mr. Goldman. Gee, we put a virus exclusion in our policies, right? Which turns out to be pretty important as events unfolded, right? We put it in, but it's just belt and suspenders. We really don't cover for loss or damage caused by a virus. Well, you know what the problem with that is, going back to Your Honor, Judge Lowy, is that we don't read insurance policies like that. We're not allowed to read insurance policies so that exclusions that are added and taken out of policies by the insurance company at their choice don't mean anything, right? And that's what they're asking you to do. They're saying the virus exclusion, don't look at that. That doesn't mean anything. The virus exclusion says we will not pay for loss or damage caused by or resulting from any virus. What loss or damage are they referring to, Your Honors, if it's not a pandemic and the spreading virus at the property? What could it possibly be? Because you see, I will tell you that we could amend this complaint.
Well, could it be E. coli? I don't know how that works, but if you've got some contamination that comes throughout the property and they can't sell food anymore.
That could be one circumstance, but we know from Strathmore's filings that's attached to the amicus brief that that's not what they meant. And moreover, we're not here, and our job, frankly, is not to go looking for ways there isn't coverage. The opposite is true. We're supposed to be reading this language as a reasonable insured would, and we're supposed to be saying, is there a reasonable way to find coverage here? And there have been many, many courts that have done so. And unless they are being totally unreasonable.
Can I ask Mr. Zimmerman, district courts, are there any circuit courts, any appellate courts, in this West Virginia case, I'm very highly skeptical is correct, by the way, but are there any appellate courts that have taken your position on the meaning of physical? Any appellate courts?
No, and one of the problems that we're here to discuss.
Isn't that troublesome when you don't have a single appellate court in the country adopting this view?
I think what we have here, Your Honor, is we have the insurance industry had a game plan. They went and got opinions from a bunch of federal district courts. The federal district courts cited each other.
Hold on a second, Mr. Zimmerman. We're talking about the Sixth Circuit. We're talking about the Eighth Circuit. We're talking about a number of the Seventh Circuit now, I believe correctly, talking about fairly distinguished number of federal appellate courts. federal district court judges acting alone. It's a much tougher job, and you're going to get diverse opinions, but we don't have one appellate court adopting your position.
Well, they haven't matriculated through the system yet. And luckily we're here talking to you. I mean, the problem is that, you know, the First Circuit did the right thing, right? The First Circuit heard argument and said, wait a second, this is a state law appellate court problem, and we're going to let the state appellate court rule. And the other circuits didn't do that. And what they're basically doing is making federal common law right in front of you, and it keeps getting submitted to you as
Mr.
authority.
Zimmerman, I want to, you've tried 3 times now without success to get to the issue of whether or not you've alleged enough in the complaint that there was COVID in the restaurant. So let's just give you a chance to do that, because I think what the argument would be if it's not there and you amended the complaint, I'm not saying that how the argument goes, but would be that, well, COVID-19 in the restaurant on the surfaces would satisfy arguably the case law as opposed to being required to distinguish it. And 3 times you've tried to tell us why and got interrupted, including by me. I have alleged enough in the complaint.
Yeah, we've alleged.
What could you tell us?
Yeah, sure. We've alleged, direct your attention to paragraph 51, 19, 22, and 38. We have attached to our complaint a diagram of how coronavirus spread when people are in the restaurant, right? And we allege in paragraph 51 that Strathmore knew at all times that access and use of the insurance properties were being prohibited because an imminent danger posed by the presence of COVID-19. Now, we could go back and we could say presence of COVID-19 on surfaces, presence of COVID-19 on the air, in the air, but we're not, first of all, we have notice pleading in this Commonwealth. And secondly, Mr. Goldman will tell you, it doesn't matter. As I said, they are not going to admit that that causes damage, even though their own exclusion says it does.
Counsel, as I think about that, and I think about all the COVID in the restaurant, right, that you're alleging is there, what would happen if the takeout clients came down with COVID and started to sue the restaurant?
I think that's an excellent question, Your Honor. And I think one of the things that the insureds have done here, to their great credit, is they have helped the insurance companies by trying to limit as best as possible their liability on the third party side, and to continue to make money and protect the insurance company on the first party all risk property insurance side. So they've done everything they can to mitigate their losses as they're required to do under the law. And so without exposing themselves and others to both danger and legal liability. So this is and that goes right back to the question of direct physical loss of or damage. You're curtailing, not using large portions of your property to protect your employees and the public. And if that's not a physical...
You know that when Mr. Goldman gets up, though, he's going to refer to other parts of the policy. He's going to talk about the triggering events of requiring replacement, rebuilding,
Yes.
Return, lost use, all of that. And why aren't those points going to be very good points?
I would like to address those 3, if I might, Your Honor. One is the period of restoration. Strathmore has quite audaciously cited the period of restoration and put a period at the end of the first clause of that provision. The provision which I'm looking at it's a measure of loss provision. It's not a coverage provision, which tells you how far afield they go to find a lack of coverage. But the period of restoration says that damages are going to start 72 hours from when the loss occurs, and they're going to end in one of three ways. When the property should have been repaired, rebuilt, or replaced, that's one. And then they leave out the other 2. And the other 2 are when the business is resumed at a new permanent location. That is a clause that does not require any repairing, rebuilding, or restoring, or 1 year from the date of the loss, which
So
again,
that's a good argument on when it ends.
right.
It doesn't help you when it's triggered.
No. It's triggered 72 hours from the direct physical loss of or damage. It
Right.
ends the lesser of. So what they're trying to do, and they say it several times in their brief, Your Honor, well, that means that the policy requires that you repair the building. The policy doesn't require that. It doesn't say that anywhere. And the coverage language certainly does not say that. And with respect to the loss of use, if I might, and the ordinance or law exclusions, that is, first of all, those weren't used to deny the claim because they don't apply here. Because if they applied here, then there would never be any coverage for business income. And there's case law. I would recommend you're reading to the Judicial versus Mass Bay insurance case about efficient cause. Once there's a covered cause of loss, you can't use loss of use exclusion to deny coverage for business income. Business income is by definition a loss of use of your business property. That's what it is. And you can't use, when there's a fire, there's almost always an ordinance of law or something that tells you you can't go into the building, right? So once there's a covered cause of loss, then those ordinance of law and loss of use provisions are of they're of no import. They can't be. And they've been interpreted that way, consistent with our position, by every single court. And by the way, Strathmore hasn't cited a single case that supports their position on those two exclusions.
Okay, I'm gonna stop you there, Attorney Zimmerman, and turn to Attorney Goldman.
Thank you, Madam Chief Justice. Let me maybe start with the question of whether the complaint alleges virus on the premises. It does not. We were pointing to paragraph 51, and paragraph 51 says that if the insureds were allowed to access and use their premises, COVID-19 would appear on the premises. Not that it does.
So they buy this all risk insurance, and now they have to sit around and wait until there's COVID in the building and people are getting sick when they've purchased all risk property insurance?
Well, that's not what the policy ensures, Your Honor, is direct physical loss of or damage to the property, not the possibility of whether there's direct physical loss of or damage to property. And the Roche case is a perfect example that's cited by Judge Kaplan, where there's snow removal for the on top of a flat roof with heavy snow accumulation, and Judge Kaplan specifically said it's not.
Don't you have to? I mean, you really don't want us to have this be based on an amendment, right? Where they're going to go back and amend their complaint and say, you know, there's going to be droplets of COVID in one of these restaurants if they're open. Don't you need to come to terms with COVID itself, being present in one of these places? Because if they were open, we'd have some presence, wouldn't we? I mean, does that change? Does the case rise or fall on whether Mr. Zimmerman included that there were droplets in one of these places?
I have two answers to that question. First, I don't believe the case rises or falls on that for reasons I can explain. But this case in itself does rise or fall. In other words, I don't believe all cases rise. If it were alleged, the result would be any different. But
I'm just
this case is very
worried,
clear what they are.
I'm just worried, Mr. Goldman, that we need to be realistic and practical. If these restaurants are open, and we have people circulating with the virus in them. That's why the governor and everyone shut them, to prevent that. So I'm nervous that the case would depend on specificity of pleading, and the Sixth Circuit sort of, agonizes over that. But I mean, do you win if there are droplets in one of these restaurants if they're open, or do you lose? Because I'd like to understand that.
Yeah,
to
sure.
me, I'm a practical person. If those restaurants are open, they're going to be droplets. So I'm just trying to get a sense of that.
Well, we win if there are droplets of COVID. We win if there's COVID in the air. And the reason is severalfold. First, there's no alteration or physical damage to any part of the restaurant caused by those droplets. Second, which is the reason most of these complaints don't allege that there's COVID on the premises, the policy specifically requires that any direct physical loss of or damage to property must be the cause of the suspension. And we know, and it's from common knowledge now that, and most of the cases mention this, COVID is cleaned. You open the windows and wipe down the surfaces, and you still use the property. This restaurant's still being used today as soon as the orders were lifted. The only thing that happened to this property was that the governor said, you can't go in there. And then once the governor said you can't use it for indoor dining. The property kept being used. It wasn't damaged. There was nothing that damaged the property. There was no loss of the property. The plaintiffs continued, there's no physical loss of the property. The plaintiffs continued to use it and are still using it today. There was simply a governmental restriction for a limited period of time on how the property could be used. Now, the second point of this is—
Counsel, why is that? How is that different than a forced suspension of operations due to carbon monoxide's presence? Because once the you clear the carbon monoxide out, the property itself is pristine. The carbon monoxide is just in the air, like COVID-19 would be in the air.
Right. I assume Your Honor's referring to the Matzner case.
No, I'm just referring to a particular example. I mean, take whatever, there's no question in my mind that COVID-19 is a physical thing. It's not, for example, an intangible substance like intellectual property would be. It's just something we can't see. It's a physical virus. So it meets the physical aspect of the definition, as would carbon monoxide. And I'm wondering what the difference in your estimation is.
Well, I don't know about carbon monoxide per se, and that Matzner case suggests there's been some damage to the chimney, and Matzner's been widely criticized as being wrongly decided by a number of judges, both within the Commonwealth and outside the Commonwealth. But I can say that it's fundamentally different from a lot of these contamination, in fact, all these contamination cases, because of the ephemeral nature of COVID. We know that COVID can be cleaned, and that if you don't do anything to it at all, it expires within a few days. There's nothing other than routine maintenance essentially needed to clean it, and you open the windows to air the restaurant out. That is fundamentally different from a situation where you've got a large-scale asbestos problem, where you have a E. coli contamination of well water, where you have gasoline that's poured on the foundation of a building, or fuel oil.
What about the smoke cases? I mean, I haven't read the Oregon theater case, the Shakespeare theater case, but there the smoke from the wildfires results in property insurance coverage, right?
It does. I think that case really stands by itself, and I'd submit it's wrongly decided and not consistent with Massachusetts law, a large body of Massachusetts law. But again, even there's something physical in smoke that's happening to the property itself. Here, there is nothing physical happening to the property. What's the problem? The problem is they don't want people next to each other, and that's what the complaint's clear on that. They don't want people next to each other breathing on one another, so that they get sick. It has nothing to do with damage to the property, and that's why the damage to the property can't be the cause of suspending business. You don't suspend your business because you've got particulates on the tables or chairs that you can just wipe off.
So your rule is there's some element of physicality that has. I mean, I think maybe it was Judge Stern who uses the term sort of, there needs to be a physical change in the property. I mean, it can't just be droplets. I'm not sure that's what the cases say, but so you define physical as physical, something physically that's transforming the property in less than a way that you can wipe it off. I mean, I'm just not sure how.
Yes, I mean, you go back to what the basic premises is: property insurance. If the waitress in one of these restaurants trips and spills a pitcher of water or spills some grease on the floor, you may not be able to use that floor until you clean it up, but it's a routine cleanup event. We wouldn't consider, there's been no, we wouldn't expect a claim for property damage. We wouldn't expect a claim for loss of business income. This is obviously COVID's more serious problem than a pitcher of water, but what it does to the property is the same thing. With the property, you come in, you clean it up, and you can use the property again, as they did. I mean, remember, people kept coming into this property to use it for takeout service, and
Mr.
then
Goldman,
they
though,
went back to using it
could-
again.
Look, I just want to go back because we're sort of jumping a little bit over the plaintiff's first argument. And that the language of the, for instance, the United States District Court for the District of Massachusetts talking about integrity of the structure or material change in the property, or something has happened that's altered the property. The plaintiff's position, the restaurant's positions are, we're just infusing that into the policy. It's not in the policy. And they what they're saying, they didn't say it this way, is they're saying that there's just a big echo chamber of decisions that doesn't really get at the underlying reasoning. And for instance, in the amicus brief talks about what we have when we have in the American food system brief, what the definition is of property of damage in the general liability provision. And it doesn't require that type of physical damage. So why is the plaintiff wrong that all these cases, what they were trying to say, and Justice Galper responded to it, that is that this is really one big echo chamber, and we're all assuming the first principle that there has to be some physicality, something that has happened to the integrity of the property or has altered the structure. Why is that?
Well, the plaintiff is wrong because you've got first, the words of the policy are direct physical loss of property. So you have to lose the property.
It's disjunctive or damage.
I understand, but the question is, what does direct physical loss mean, or what does direct physical damage mean? Or what
You
does
just
damage?
put physical damage into the policy. It's not in the policy. You just said or physical damage. The policy doesn't say physical damage. It says or damage. I'm not saying you're not 100% right. I don't know. I have no idea. But I'm saying that we're jumping over the plaintiff's first argument.
And that
argument is, if you want me to say it again, that there's something that has to happen to the property that's altered it, a material change, that something about the integrity of the property that gets infused into these decisions. They say that's not required. Just look at the definition in the other part of the policy.
Well, if we look at the other part of the policy, the Second Circuit specifically correctly pointed out, the other part of the policy is a definition of a specific term, which is property damage, which is not, and which is a defined term with the words used in that sequence. It's not used here, and that term's not used here.
Okay,
and the Second Circuit,
that's wrong. That's wrong. And I wish I hadn't put that tail onto the question. Answer the core of the first question.
So the first, I think if you look at the other provisions of the policy, you look at the loss settlement provisions of the policy that talk about the cost of repairing or replacing the property. You look at the actual period of restoration provisions. And the simple fact we add a year limitation by endorsement. I mean, the basic form does not have that additional language. We did miss that when we did our brief. There's an endorsement that also said, but not more than a year. But that's simply a time limitation. The fact that and the textual clues in the policy are specifically referring to repairing, rebuilding, or replacing the property suggests we're talking about something that requires repairing, rebuilding, or replacing. There's nothing here to repair, rebuild, and replace. And we look at the loss settlement provisions in the policy, which Judge Sanders below noted, there's nothing, I mean, there's nothing here to repair, rebuild, or replace, and that's what the loss settlement provisions.
Mr. Goldman, can I ask one? The theft is also covered, right? If the property is stolen, so that doesn't require physical damage, right? It's a loss without damage, theft, right?
That's exactly correct, Your Honor. And that's so loss of property would mean permanent dispossession or permanent or indefinite dispossession of property. And if we had a physical condition that was a permanent or indefinite a condition that could not be would not go away without something other than routine maintenance, then we might have a direct physical loss in the same way we'd have theft. And that's where those environmental cases all fit in. That's where the fuel oil cases fit in. That's where the gasoline and the building foundation in Colorado fits in, because we have a condition that makes the building completely uninhabitable until and unless there is affirmative, complex, and expensive repairs done, or not even repairs, remediation done. That is not the case here. Here we have a condition that by its own forces, if the insured did nothing, building would be perfectly fine to use within a few days. If the insured cleans it, it's ready to be used much more quickly. There's no better evidence of that than that's exactly what they did. They used it for initially for takeout dining. Then later they used it as soon as the government allowed them to. They used it for in-house dining, which they're still using it for. So there's nothing happened to the property, which is fundamentally different from a situation where you have to spend hundreds of thousands or millions or tens of thousands of dollars to remediate a problem, or you will never be able to use the property again. And that's the difference between the cases that the plaintiff relies on and what the policy language says and what it interprets. Because remember, this is property insurance, and we're insuring damage to property, and then to the extent that damage causes can
I ask then, why do you
mention?
So Mr. Zimmerman points out that you can buy virus exclude. If it's so obvious that viruses are not covered, why do you need an exclusion for viruses?
Oh, because these are restaurants and it's food. It's food. I mean, it's in other words, it's exactly what I think it was Justice Lowry pointed out. When you look at the submission that's attached to that was submitted to the New York regulators, that's attached to the amicus brief, that's what they're talking about. They're talking about two things. They're talking about contamination of food and the other situation which I talked about, which is Legionnaire's disease, where you have to basically dismantle the entire HVAC system in order to be able to use the building again. Those again are fundamentally different than this type of law.
So the virus exclusion is limited to okay, so again, I'm a little troubled why Legionnaire's disease is so obviously not property. Legionnaire's disease gets into the air conditioning units, right? Again, I will defer to my scientific colleagues here, but so why wouldn't that be property damage? You get this disease into the air conditioning system, and it's hard to root out. So that's not property damage?
No, we believe it would. I think Your Honor misunderstood me. We believe that would be property damage because there's a extensive thing you have to do with both money and labor involved to repair that problem in order to be able to use the building at all. Otherwise, the building is completely uninhabitable indefinitely. And that is the difference with this.
So Legionnaire's disease would be covered because it's hard to extricate from the physical. It contaminates the physical structure, while this thing just hangs in the air or drops on the tables. Okay, I think.
Well, it hangs in the air, drops on the table, and goes away in a few days. I mean, it doesn't go. It becomes non-contagious in a few days. It becomes inert. I mean, it becomes dust effectively, or you can clean it much more quickly and it becomes nothing. Pardon?
over, if with the chief's permission, I have one more question.
Well,
that
before you get off that, I just wanted to understand, are you saying that the exclusion would make it so that Legionnaire's disease was not covered under the virus exclusion policy? I mean, under this policy that has a virus exclusion?
Under the policy that has a virus exclusion, Legionnaire's disease would not be covered because the exclusion applies to both virus and bacteria, and Legionnaire's disease is a bacteria,
Okay,
not a virus. Right.
all right, thank you.
Uh,
Justice Wendland?
that was
Oh.
my clarification.
Oh, I'm sorry.
Yeah. So
Okay,
if I
thank you.
may,
Well, I think you've gone well over, and I think you've made all your points very well. Thank you so much,
okay, thank you.
Attorney Goldman. And we'll have Attorney Ferguson. You've got 2 minutes, or maybe a little more. Everybody else got a little more. Go ahead.
Thank you, Madam Chief Justice, and thank you, Your Honors. Good morning. May it please the court, Andrew Ferguson on behalf of Commercial. I don't think I'm going to need much more than my 2 minutes, quite frankly, Your Honor. And the reason for that is the claim against my client is a simple one. There's 2 different policies here. There was a policy that was issued to Corp. There was a policy that was issued to Little Donkey. The Little Donkey policy had the virus exclusion, whereas the Corp. policy did not. The sole claim against my client is procuring a policy for Little Donkey that had the virus exclusion. So in order for Little Donkey, in order to be able to succeed on its claim over and against Commercial, it has to be able to establish that it would have had coverage under the Strathmore policies, but for the virus exclusion.
And if it did, would there be negligence?
If it did, would there be negligence? I don't know if, I don't necessarily agree that there would be negligence on the part of Commercial for procuring a policy for its client that had the virus exclusion. No, I don't say that that would necessarily be negligent. I think what we would have to do then, Your Honors, is we'd have to go back and have a factual discovery as to why there was a virus exclusion on that policy and how that came to be. And I don't think that necessarily is dispositive at this stage. What I'm saying here at this stage is that if there is a finding that the policies do not afford coverage, but for the virus exclusion, then you don't need to reach that issue, and the judgment on the pleading should enter for Commercial. That's it.
Do we have anything in this record that informs us why we have common ownership of these 3 restaurants, right? Why
Correct.
one has a virus exclusion and the other 2 don't? Do we have anything that informs us on this?
We have nothing on this record, Your Honor, that would inform you on that issue now. So Your Honors, I would just say on that point, I would otherwise just, I'm sorry, Justice Gapker.
And nothing in the complaint that explains the reason for this difference. There's nothing in the complaint.
Well, I think the complaint makes allegations about that virus exclusion being inserted by Strathmore under, for lack of a better term, some nefarious circumstances. But that allegation has been made, but I don't think there's anything on the record that truly establishes why that exclusion was in that policy, yet not on the Corporatorial policy. So with that, Your Honor, I'd otherwise just rest on my brief. But I would say, I would just like to echo, Your Honor, that I don't think that this complaint alleges that the virus was present at this property. I think it alleges that the virus was everywhere, but it doesn't say it was at this property, nor does it say that there was damage done to the property, physical damage done to this property as a result of the virus.
Your position, counsel, is that makes a difference?
Well, I don't know if to be honest with you, Your Honor, I don't know if it necessarily does make a difference, because I do tend to agree with what the case law says.
Does it make a difference or doesn't it make a difference?
No, I don't think it would make a difference, Your Honor. And the reason for that, I think, is because for the reasons we stated by Attorney Goldman.
I understand the reasons. I'm just wondering if it makes a difference. So
I would submit it would not.
Okay.
It would not. And with that, Your Honor, I'll rest on my brief.